Good morning, everybody. You're all very welcome to this morning's webinar from the education team in Mason, Hayes and Curran. And today's webinar is entitled, How Recent Case Law May Affect Your School. My name is Ian O'Herlihy, and I'm going to start by introducing my colleagues, Catherine Kelly and David Ruddy, both of whom will hopefully be familiar to any of you who have joined our previous webinars. I suppose just a word of warning, I am just back from a 10-week sabbatical. So if I start talking gibberish, all you teachers will understand it's like I'm back on the first day of a new school year after the summer break. So please excuse any nonsense I talk along the way. Today we're going to discuss some recent legal decisions. Ones that are kind of helpful, hopefully, to share with you and your schools. We're going to look at things like WRC decisions, court judgments, and also kind of in the wider sense, when I talk about cases, disciplinary appeal panel decisions. We've had quite a number of those in the last, say, COVID 2 years, maybe some Section 29 appeal decisions, and maybe look at some of the kind of learnings that we've had from those. This is certainly not intended to be an exhaustive review of all legal decisions over the past 2 years. That would take a very long time, but rather we're trying to focus on a few selected issues. Can I just say, as I usually say in these webinars, the chat function is off because there's many hundreds of people have registered, and it isn't really possible to operate effectively a chat function with large numbers. But you will, and I'll give you a reminder about this at the end, but you will be invited to send in comments, and that's very important for us. It keeps us on our toes at the end, to let us know what you thought of the webinar. So if I put up the first slide there, damned if I do and damned if I don't. And what that really is dealing with is a situation that we have addressed and spoken about before on webinars, where you have two parents who disagree with a decision to enroll a child in your school. And sometimes not only do they disagree on that, but they're at war about everything. And while we've dealt with this before, we've had quite a lot of situations of this during the last 12 months, where two parents and two guardians are in dispute. And by way of recap, just all this stuff from previous discussions or webinars. We had a new Admissions Act in 2018. That unlike the previous regime, decisions in the first instance on admissions are taken by the principal. It used to be by the board. Obviously, you have to comply with your admissions policy and your admissions annual admissions notice. And if you have a place in your school for an applicant, you really have very little discretion. Now, I have a little small question mark over the last bullet point there. You must accept. There are very, very limited circumstances in which you can refuse an applicant where you have a place available. So if we move on from that to the next slide, and I mean, just to mention that, dealing with the so-called New Ireland, we had the Children and Family Relationships Act of 2015. And what that act did was it recognized that there are now what are referred to as non-traditional families. And the family structure that would have been, 90-something% years and years ago of a mother and father who were married, there are a whole range of different situations. And what this act did was extended quite a lot of both the rights, but also the duties to non-traditional parents, and particular fathers and non-traditional guardians. So I think we should get stuck in. I'm going to pass over Catherine, who has represented and advised numerous schools who have found themselves in this difficult situation of having to deal with an application by one parent to enroll their child in the school, and either prior to enrollment or subsequent to enrollment, a challenge from the other parent or guardian. Catherine, you've had a couple of interesting cases.
I've had two really good decisions for schools in the last 6 months. We've had a lot of issues in relation to disputes between a father and a mother in relation to enrollment of a child. One person says, I want to enroll the child here. The other parent says no, they object to it. And we've had claims of discrimination from the fathers in particular in relation to marital status and gender, and saying they've been discriminated against because the school has enrolled this child without their consent. We had a few Workplace Relations Commission decisions under the Equal Status Act which awarded compensation to these fathers and stated that they had been discriminated against, so we couldn't allow those to stand. We had to appeal those to the Circuit Court, because obviously that would present schools with problems all over the country. Schools would have to enroll these children, otherwise they'd be faced with a Section 29 appeal, which they would lose. So it was very important that we would get those overturned. So we appealed and we got two very good decisions. The first one was in relation to a community school, and the court there noted the impressive exchange of correspondence between the parties. We had been in correspondence with the father to say, we now know that you are joint guardian and we will treat you as such, but we are still going to enroll the child. So the judge complimented both parties in relation to those exchanges. And they noted that almost 4 months elapsed without any further communication from the respondent, from the father. So just 2 weeks before school was due to start, he started up again in relation to the fact that he was being discriminated against. But the court felt that he should have gone to the family law courts during that period to try and sort it out, and shouldn't be going to the school to say that he was being discriminated against. Judge made the comment that there was an obligation very quickly upon the school to enroll the child, and that the school is under an obligation to that child. And there are rights in law which thankfully apply to children as much as they do to parents. And that's very, very important. So the court was saying, this child has to be in a school somewhere. And if you can't agree about it, you go off to the family law courts. And that's the key here. If you go on to the next one, this was just recently a very important one then in the Circuit Court in Dublin, which stated that the rights of the child are of paramount importance, not the squabbling between the parents. The parents need to go and sort it out themselves in the family law courts. So the judge there said that the Workplace Relations Commission should not be used by a parent or a guardian in upholding their gender rights as a substitute for a court in dealing with what are essentially family law disputes. So again, we got a very strong judgment that it's up to the parents to sort it out in the family law courts, and you shouldn't be involving the school, because the school has to enroll the child if they have a place and it complies with their admissions policy. Those are the key takeaways for those cases. And I think David is going to deal with another case that has a similar issue, but a little bit different to those ones.
Thanks, Catherine, and good morning, everyone. And Catherine, can I just ask you, like, I know with the second case that you've referenced there on the slide, you felt very confident going in on the foot of the first case that you had been successful in.
Yeah.
Going back to the first case, when the WRC awarded the parent a few €1,000 against the school, I mean, you were down 1-0, as it were, at halftime, and I know you're a Galway woman and you never say die, but did you feel confident in that first case? Second case, I know.
Like a true Mayo man there.
God, this is getting personal now. But
no, I felt that we were on a good standing, because those WRC decisions went against the previous case law, and we can't allow it to stand that, you know, schools have to go looking for signatures from, you know, two parents. We don't know where the second parent is. Sometimes it's not up to the school to clarify those issues, and I felt that a circuit court judge would be able to see those practical issues. And I was also helped an awful lot by the great evidence that both principals gave to help our cases.
And one thing, David, that just came out from those two decisions was the fact that the school, notwithstanding the fact that they didn't agree with the in this case, most cases, the father, but not, they engaged with the father.
Oh,
Like
absolutely.
they didn't just ignore the correspondence. That was
Yeah.
very crucial.
Yeah. I mean, schools will treat both parents equally. That's the way, you know, it happens. And it's very important that they do. However, they will have to enroll the child.
Yeah.
And that's the bottom line.
That's really very reassuring for schools, and thanks for sharing that, and particularly the idea of keep the communication lines open at all times. Yes, this next case that Catherine alluded to will just show you, if you think it's difficult at times having as principal to make a decision, and you have parents at war, unfortunately, this case here will give you an example of what the courts had to deal with. And it was a case of a sixth class pupil transferring to a post-primary school. The parents, unfortunately, were separated, and there was a dispute over which school the pupil should attend. Now, Dad wanted the boy to attend the local non-fee paying school because a lot of his friends were going there. But there was another reason too, financially, even though they had an education fund, there was an older child who had special needs, and he felt that he hadn't the means to support the child going to a school other than a non-fee paying one. Mum had a preference for a fee paying school, and her parents were prepared to assist her with the fees on that, but the dad felt this wasn't sustainable long term. So the case was taken, a case was taken in the circuit court, and the judge, you know, said that she was quite uncomfortable having to make that decision. So the question is, and it was appealed subsequently to the High Court, did the courts rule in favour of the father who wanted the non-fee paying school or the mother who wanted the fee paying school? And I'm going to ask you to participate in an online poll. So put yourself in the case of the judge. What way would you have ruled? And I know you haven't all the details, but you have a basic outline on that, just to give us an idea. So you might start voting now, and
I'd say all the fee charging schools, if they're true at this, they will definitely opt for fee paying, and all the non-fee paying will opt for non-fee paying. I bet you. No, I'm only joking, but
yeah, well, that's
we'll see what some of the people listening may remember the case, because it did get a bit of publicity at the time, you know, a year or two ago.
They'll have the advantage.
Yeah, they'll have the advantage. Yeah. They'll have insider knowledge, you know.
So Carolina, thank you very much. She has the result there, and 16% would have ruled in favour of the fee paying, and 84% in favour of the non-fee paying school. Well, that's emphatic. Well, the good and the bad news is you're partly right. Both views. The circuit court judge ruled in favour of the non-fee paying school and the father, and on appeal to the High Court, the judge ruled in favour of the fee paying school, but with the proviso that if the mother couldn't come up with sufficient funds, that they could come back to the court and they would revisit the question. And the judge, of course, said in the High Court that this really was a decision for the family to make, and reluctantly he got involved. So a win in the circuit court for the non-fee paying, and on appeal for the fee paying school. Okay, we're going to move just to a summary of this, Ian, in one slide. If you can pull the legislation and the case law together.
Yeah. Well, this is just basically a sort of a quick recap. Is one signature enough on an application form to enroll? And the answer really is, of course, like 2 signatures is the best, but a school really is obliged to take 1 signature, not least because, I mean, the world in which we live, there's a lot of single parent families or whatever. So, you know, you ought not to insist on 2 signatures in all cases, in any circumstances. Be very careful about withdrawing an offer of a place made, because if you look in actually the Admissions Act, there are very limited circumstances in which an offer can be withdrawn. The main one is where an offer was made on foot of information proffered by the parent, which has turned out to be untrue or inaccurate. That's the main one. But be very careful about withdrawing an offer made. I'm not saying it never can happen, but just be careful. What if a school is put on notice of a conflict before a decision on offering a place is made? And this is a situation that everybody on the team has dealt with this. In other words, before places are allocated, mum and dad make it clear that they're not in agreement with the child going. One wants to enroll, one doesn't. And we have a kind of a letter. I'm not saying it's a standard letter, but we have the bones of a letter that we have sent out to parents in those situations, which basically says, look, we can't sort out this between you. We're not a court. If you have a problem in relation to the education of your child or where your child should be educated, you need to go to the courts to sort this out. We've got an application to enroll. We've got an objection. And if there's a place available, we're going to offer that place and go off and sort that out. And in several of the cases that we've had, one or two that Catherine has referenced, a letter along those lines has been issued, and it has been commended by the courts and by the WRC as being reasonable for a school to issue a reasonable sort of letter. So this is just picking up on the kind of don't ignore the parent who is objecting. Engage with the parent, but you can't. You have to, damned if you do, damned if you don't. And our attitude is, if you have a place available, you enroll.
And one point I'll make on that as well is that the courts will very much focus on the child and the interests of the child. And in the second case in particular that we had, the principal involved gave great evidence in relation to his only focus was there a place in the school? The child, needed to be educated, had a right to education. Is that child to be kept out of school while the parents sort it out in the family law courts? That can't be allowed to happen. No. And that was really, really useful from our perspective for the judge to understand all of those issues.
Yeah.
Thanks for that. And we're now going to move away from admission, and we're going to look at the whole question of employment and reasonable accommodation. And again, Catherine, you have a case literally hot off the press. So I think you'd like to share it with us.
Last week.
Yeah.
So it's one of these thorny issues that I know you all come up out with allocation of classes. A particular teacher wanted a certain class, and the principal couldn't give it to her because of health and safety reasons. And she brought a discrimination claim to say that she hadn't been reasonably accommodated in relation to her disability. But the decision was very good. It was in our favor in that the board had looked at all of the different options available and had given a reasoned decision to that teacher as to why they felt that they couldn't give her the full-time SET role. And it was based on health and safety and the medical needs of the teacher, okay? So that's the only obligation is to try and reasonably accommodate someone when you're allocating classes. But there was no discrimination in this case, which was a great decision for a school. And if you go on to the next slide, you can see that there had been extensive correspondence with the department and Medmark. They had tried to get another teaching position. They had tried to get Medmark to give recommendations, and the adjudication officer commented on that. He also felt that the board were the best people to comment on whether or not there were health and safety issues, and they didn't have to bring in an independent health and safety consultant because that was what was being argued by the other side. So it's a very, very important decision for schools.
And just to say, David, like some principals have said to me, like their head is kind of a bit scrambled in terms of trying to understand, they hear discrimination because Catherine has just spoken about a discrimination claim by a parent in relation to an admissions thing. And here we have a discrimination claim by a staff member. And it's helpful just to say the following. I mean, there are two separate pieces of legislation. There's employment discrimination. Employment Equality Acts. And then there's the legislation that extended all of the discrimination law into the sale of goods and supply of services. And that's the Equal Status Act. And if anybody has any questions as to whether, education is a supply of service, it is, because it's specifically mentioned in the Act. So I just want to mention that. And also just one other factor, and that is, like, discrimination, whether it's in pupils or it's members of staff, is defined as less favorable treatment. So there's 9 grounds, less favorable treatment. One of those grounds is a disability. So you can't obviously treat somebody less favorably on that ground. But there's an extra obligation on a disability ground, which doesn't exist on the other grounds. And that is, if somebody is disabled, student, member of staff, you have to provide or make reasonable accommodation for their disability. Now, obviously, there's a lot of case law what is reasonable, but I just wanted to say that because sometimes principals have said they just find it difficult to understand where all this stuff, discrimination stuff, sits. So I hope that's kind of helpful.
But yeah, I mean, the onus is the onus is on the school to try and reasonably accommodate.
Yeah,
that's not an absolute, obligation. The board here went through every option and couldn't give her the full-time SET role. So they did try to reasonably accommodate her. So they didn't discriminate. So that, that's the bottom line there. And
Catherine, I think one of the standout elements of that particular case was that the school had written really, really sophisticated letters, saying, look,
with our help.
Yeah, with our help. We blow our little trumpet.
On the back here.
No, but said, look, we want, we understand what you're looking for.
Yeah.
One of the things they did was they applied, just for the sake of it, they applied for additional resources from the department, knowing perfectly well they were what they'd been told, which was get lost. But they were able to produce that to show, like, this was engagement with the particular teacher. So it was, and that correspondence, and there was a lot of it. There was a big book of it, really was very crucial in the end.
Yeah.
But ultimately, isn't it really the job of the board to manage a school? And in this situation, had the board not taken the stance they did, the teacher would be dictating what classes the principal would be taking and another teacher in the school, which would totally have undermined. Would that be your take?
It's well established that it's the principal who allocates the classes. There's case law on it. So, the principal makes the decision. Now, when there's an issue like this, the board does become involved, but it wasn't just a rubber stamping of the principal's decision. It was a detailed analysis of what could be done, which really stood to us really in the end, because we could prove that we had looked at it properly and in detail.
This gives great reassurance to school leaders, and I think it's a case that people will be referring to and going back to time and time again. So thanks for that. We're now going to move on to the whole question of appeals to the disciplinary decisions of the Disciplinary Appeals panel. And Ian, I know that you want to say something about this.
Yeah, I don't know why it is, but we've had a lot of these decisions over the last 2.5, 3 years, particularly during the COVID spell, although I'm not sure that they're necessarily, with one exception, that's really related to COVID spell. So just for those who aren't familiar with this, you all know there are disciplinary procedures for teachers, and there is an appeal mechanism whereby a teacher who is unhappy with particular sanctions that have been imposed by school management can appeal to an independent disciplinary appeals panel, a 3-person appeals panel, 1 person nominated from the management side, 1 person from the union side, and a chairperson from a panel of people essentially appointed by the minister. So there are very strict grounds upon which a teacher can appeal. And I just want to read these out to you. And the reason I'm reading these out to you is because each appeal, and we've attended a lot of them, will deal with a forensic examination of these grounds and only these grounds. So the grounds are, and I'm reading from one of the decisions here, the grounds are the provisions of the disciplinary procedures haven't been adhered to. Number 2, that all relevant facts were not ascertained. Number 3, that all relevant facts were not considered in a reasonable manner by school management. Number 4, that the teacher concerned was not afforded a reasonable opportunity to answer the allegations of the disciplinary issues. So that's a hearing. The next one is the teacher concerned could not reasonably be expected to have understood that the behaviour alleged would have attracted disciplinary action. And that gives rise to things like warnings and those sort of things. And the last one, perhaps the most important one, is that the sanction recommended is disproportionate to the misconduct alleged. And you'd expect that would be in there, because clearly when you come to the serious end of sanctions, there's got to be matching misconduct or whatever that would justify that.
Ian, typically, could you give us an example of the typical sanctions that you would find yourself?
It's the sanctions that have come before that we've been involved in have been, as you might expect, that we've been involved in before the disciplinary appeal panel have been at the serious end: dismissal, demotion, suspension. That's really the ones that have come up.
We've had one in particular of suspension without pay because of a refusal to attend MedMark.
Yes, yeah.
To a disciplinary appeal panel, and I attended with the client, and it was, the disciplinary appeal panel just said, well, you have to attend MedMark,
Yeah. So I'm just literally in 2 minutes, I'm just going to, I have a big bundle of these decisions here that we have been involved in the last 2 or 3 years. And I'm not going to give you facts, individual facts, because in fairness, they should be anonymized. So you'll bear with me that understand that this is, but I want to give you a flavor of the kind of, and we really to encourage you that the vast majority of decisions that we have had before the DAP now have been upheld. So if we just run through some very quick ones here. A national school, a lot of parental complaints, a lengthy investigation, the board dismissed the teacher, and the dismissal was upheld unanimously by the 3 members of the Disciplinary Appeal panel. So that ought to be an encouragement. Now, obviously, the devil is in the detail. Secondary school, a teacher was on a final written warning, and there was further serious misconduct, and the sanction of dismissal was upheld by the Disciplinary Appeal panel. A national school, parental complaints, teacher was dismissed, the Disciplinary Appeal panel upheld the dismissal. A secondary school, a majority 2-1 decision, gross misconduct. The Disciplinary Appeal panel commented that there was no remorse on the part of the teacher and no insight into the teacher's misconduct, and referenced kind of trust and confidence, and decided that the sanction of dismissal was proportionate. A national school, a majority decision, overturned the dismissal sanction and replaced it with demotion and loss of allowance. And 2 more, a secondary school, that the teacher was suspended without pay until certain terms were complied with, and the Disciplinary Appeal panel decided that was not disproportionate. In other words, upheld the board's decision on the basis that they hadn't complied with the decisions. And the last one, which was very interesting, I thought, was a secondary school where a teacher refused to comply with, in particular circumstances, with COVID regulations. And they got warnings and double warnings and were suspended and blah, blah, blah. And eventually they were called to a disciplinary hearing and they were dismissed. And the Disciplinary Appeal panel overturned the dismissal, but at the hearing, more or less recommended that the teacher be suspended without pay until they complied. Because I think my reading of it was because they said this COVID thing isn't going to go on forever. and whatever. So I just wanted to give you those flavor, and really to say that if you comply with process and the disciplinary process, you're down simply then to this issue of proportionality. And, you know, the decisions that I've read, you're not certainly going to win, if you know what I mean, but the decisions I've read should encourage you that you have a very good chance that your decision will be upheld. Your decision will be upheld, your sanction will be upheld. Just the last one sentence. Technically, the decision of a DAP is actually framed as a kind of a recommendation. In other words, the Board of Management is not absolutely obliged to comply with it, but our advice really is that you'd be very slow, and wouldn't say never, to ignore it. David.
Ian, thanks for sharing those cases and outcomes with us, which I think will be encouraging for schools. But just one question, why are schools so reluctant to engage in the disciplinary process in the first place? Because talking to people like the PDST, who offers supports to schools at the initial stages, and indeed to teachers on that, there's a huge reluctance to engage with the machinery. And what would your take or Catherine's take on that be?
Well, I think one of the reasons is a historical take that it's impossible to discipline a teacher. And, you know, this is going back maybe to times before there were disciplinary procedures there. And also to the realization that the teacher unions are very strong and they will represent members. But I have noticed in the last couple of years that there is, when principals and boards have got more familiar with the disciplinary procedures, that there's less of a reluctance. There's still a huge reluctance on the part of principals to follow to adopt the competency procedures, which is another day's work. But the disciplinary procedures around conduct, I believe boards are more familiar with and principals are more familiar with, and they understand that yes, there's a risk that they might be challenged, but they're much more ready now to weigh up the risk of not taking any action.
Yes,
which carries lots of risks in terms of parental accountability and things like that.
Thanks for that, Ian, and that's been very helpful. We're now going to move away from the whole question of employment and reasonable accommodation to pupil behaviour in schools. And last September, some of you may have attended and participated in a poll we did in relation to the whole question of behaviours of concern. And one of the questions you can see there is managing challenging behaviour an issue for your school? And we saw that 75% said yes, which is not surprising. However, what was surprising from my point of view was that 2/3 of school leaders didn't feel confident in dealing with these behaviours. And just drilling down into that and talking to some school leaders in relation to those figures, what we're hearing back is schools are increasingly dealing and accommodating pupils who have even more complex needs than heretofore. And I suppose parallel to that is the lack of available supports to include assessments. And maybe that's the reason why they don't feel as confident as they ought to. Another reason, we would have mentioned, it was coming down the track, but it's very much up and running now, is the reduced school day. The department have basically said, unless the consent of the parents is forthcoming and TUSLA is informed, that schools cannot use it, and they cannot use it as a behaviour management tool. And it can be treated as a suspension rather than a reduced school day. So schools need to be aware of that. And some we have also found from inquiries to our office is that some parents who might have agreed to a reduced school day are now changing their mind, having been put on notice of this particular circular. We're speaking of discipline. Ian now is going to share a few thoughts with you, in particular in relation to the NEW guidelines. So over to you, Ian. Thanks.
Thanks, David. Well, again, I don't make any apology. You've heard us mention these before, and I'm going to talk in a moment about the main, if you like, the main planks of the guidelines that you really have to follow. But the first thing, just to make it by way of general comment, is they're called NEWB guidelines, but they're not really guidelines. And anybody who has ended up in a Section 29 appeal will know that if there is any kind of a flagrant non-adherence to the NEWB guidelines, you are very likely to lose a Section 29 appeal. So guidelines in name, but not, they're really rules to be followed in practice. And, they provide for graded sanctions. And this is getting back to, I spoke a few minutes ago about disciplinary sanctions for teachers, but again, there has to be a proportionality element to sanctions imposed. So you can't simply, go to the end game, except in very serious circumstances where you have, a major event of serious and dangerous misconduct. Obviously, look, you don't need me to tell you, you need to follow your school policy, because if you don't do that, you are rightly bunched and you're 2-0 down in the match. And all of this it has a legal basis, because all of this is set out in the Education Act, Section 23(3). So, they're the sort of the very high level things. What do Section 29 appeal committees look for? Well, again, this sounds a bit like the disciplinary procedures for teachers. They look for fair procedures. They look for compliance with NEWB guidelines, and they look for proportionality. They look for proportionality of sanction. But there regularly are expulsions challenged by parents by way of Section 29 appeals. They tend not to, legal challenges for lesser sanctions tend to be pretty rare. Section 29 appeal deal with expulsions, also failures to enrollment. And there have been judicial review outcomes, which I think we might spend a moment just to look at. If we just go on to the next slide, I'm going to ask Catherine to deal with.
Yeah, I mean, we've advised on quite a few expulsions, recently, and a lot of them don't end up in Section 29 appeals. They're just accepted and the child moves on. We had one in particular, which was a serious case of a child who was injuring staff very seriously, other children, and he was a health and safety risk to himself as well. The expulsion was overturned by a Section 29 appeal committee, so we judicially reviewed it and went to the High Court. And the High Court held that there was a huge health and safety risk, went back for another Section 29 appeal, and the expulsion was then upheld. And the decision of the board was final in relation to that. He was expelled. So, it showed that you have to go through, as Ian said, they're not guidelines. You have to comply with the NEWB guidelines. You have to look at everything that you can possibly do to keep that child in the school. NEPs, getting extra resources, anything you can possibly do before you hit the nuclear button and go to expulsion. It's really, really important that you try extensive interventions before you go down that road.
And just to say, Catherine, that like in preparing for today's webinar, we were just talking among ourselves and saying, like, our response to boards, and we don't make any apology about this, our response to principals and boards who come with a possible challenge or indeed a possible expulsion, we see our role as being the devil's advocate. We see our role as stress testing the school's procedures. And very often, I don't know if we necessarily get popular, but very often with schools, we say, no, I don't think so.
I had one yesterday that I said to the school, I said, no, we shouldn't proceed here. We need to go back and look at it again. That happens a lot, with our advice. Yeah.
So the bar is very high, isn't it, really?
The bar is high. Exactly that. Yeah. And you're better off hearing the bad news from us than hearing it from a Section 29 appeal or a court if you went and challenged something, you know. So that's our attitude, just to say.
Yeah, and thanks for that. Just an example of another case where a Section 29 appeal committee took a decision and it was appealed then to the High Court. And this was a case where you had a primary school student who had a history of behaviours of concern, and in one particular incident, he assaulted teachers and students with a hurley. His expulsion was proposed. The Section 29 Appeal Committee took the view that the student should be allowed back to the school unlimited hours, which was quite unusual. That was a recommendation. The Secretary General went one further by stating that the students should be sent back to the school on full hours, despite the seriousness in the view of the school in relation to the pupil's action. The Section 29 committee finding was quashed, and in the High Court, Judge Humphreys basically was satisfied that the bar was reached in relation to the school's action, and said that the committee didn't give due consideration to the code, to the actual nature of the behaviour itself, health and safety, and finished off by stressing that the school had a duty of care to everyone in the school. So again, these cases can give us reassurance that if your paperwork is in order, going back to Catherine and Ian's ideas, of communication, of writing, and doing everything possible, as alluded to in the previous case, that the courts will be fair and reasonable. And in relation to the whole question of a disciplinary hearing in relation to pupils and that, Ian, you just wanted to give us a few little tips on that.
Well, yeah, I mean, these are all in the NEWB guidelines. So this is not an exhaustive list. We say to schools every single time, because we do it ourselves, get out the guidelines and use that as a check to see that you have your ducks lined up in a row. But I mean, here's a couple of basic things that if you don't get these right, you're bunched. There has to be a disciplinary hearing. The principal presents, if you like, the case to answer, so-called, to the board in the presence of the parents. And the parents can challenge and respond to the principal in front of the board and say, no, I don't agree with that, whatever. The principal and parents leave the hearing at the same time, and the optics of this are really important. Now, preferably the principal and the parents come into the meeting at the same time, because again, the parents can have more confidence that the principal isn't in there, sort of at the decision making. The Board of Management deliberations following the hearing, they don't make any decisions prior to that. And very importantly, because there's been a High Court case on this, you can't, even if the board decide that a child is to be expelled, you cannot expel them immediately after the disciplinary hearing. And this is because of the technical wording of the legislation. You have to issue a notification of sort of intention to expel and wait for a period of 20 school days, during which there are consultations with the EWO, the theory being that perhaps the expulsion decision might be changed by a board, or perhaps the child might get into a different school, and it's happened that the school has been asked, well, will you revoke your decision on the basis that the child will leave the school and won't then have the if you like, the stigma of an expulsion. So there's all these negotiations going on. Just watch out for those two things.
It's very important that you calculate the 20 school days very correctly as well, because we lost one on that basis. Yeah. You have to take into account midterm breaks, any kind of, days off, and be very careful about it.
I had a board, a primary school board, on earlier this year, and they wanted to say, well, no, they wanted to go 21 days. I said, oh no, please don't cut it down to the thing. Don't go 21 days. Go 25 days, but don't cut it down to the bone, because you get into an argument then. So just do's and don'ts before we leave this point. Expulsions, make sure your policy on expulsion is incorporated in your code of conduct. That's in the NEWB guides. Make sure that there's a reference in your code of behaviour to to the board's statutory obligation to provide staff with a safe place of work. And that's touching on some of the cases that Catherine has spoken about, because, if you have, violent or, assaults on members of staff, it's a balancing act between your duties to the student and your duties to the staff. And it's good to have that referenced in your code of behaviour. Just 4 don'ts. Don't forget to notify the EWO. This is the 20 school days. Don't forget to advise the parents that they maybe should be accompanied to the hearing. Don't forget to participate don't forget you cannot participate in the board's deliberations as a principal. And lastly, don't forget to notify their parents of the right to appeal on Section 29, because the clock doesn't start to run until you have told the parents that they have a right to appeal. Otherwise, it's kind of open-ended until they've been advised about that. So don't forget to do that. David.
Thank you, Ian. And notwithstanding what Ian has said in relation to expulsions and the case law we've looked at, we have said and reiterate that the bar is very high. And also, previously, we said that schools have to accommodate a lot of pupils with complex needs. And the question I suppose we'd ask, is there specific department guidance in relation to physical intervention? What happens when a pupil gets involved in a fight on the yard, attacks somebody, a member of staff? What do we do? We don't have any specific guidance from the department at the moment. We have in the UK, and then you have the likes of New Zealand, who have something similar to our child protection procedures, where there's legislation and very solid guidance. But we can predict what would be in guidance if the department published it. And among the things, and we just briefly reference this, is that there would be an obligation to intervene if a student had a weapon, again, physically attacking, and as referenced, running onto a road, etc. And the big thing, what we'd ask you to reflect on is, would you rehearse how you would handle a situation like that? I mean, every school in the country rehearses fire drills on a termly basis. And it's not a matter of if something like what's on the slide there will happen, it's when it'll happen. And it's really important, we would say, that you should rehearse these situations. We also would advocate that you should have a behaviour concern policy that would be appended to your code of behaviour. And again, one of the things in relation to admission, in relation to staff disciplinary issues and pupil disciplinary issues, and again, Catherine and Ian would say this, it makes life much easier when you're representing a school, is to record and report, to have good notes, to have good records. And in relation to behaviours of concern, a risk assessment is really important, where we look at the risks and what are the control measures we can put in place. Recording and reporting won't eliminate behaviours, but it certainly will help manage them. And again, if you have to go down the expulsion route, or that documentation, what your SNA, what your teacher has written in a report, will be very important. So we've come to the end, and on focal Geranach again. So Arialat.
Very good. Well, look, these are bog standard stuff. There's no sort of huge complexity to what I'm going to say. Admissions. You'd be surprised at the number of disputes arise where somebody can point to failure to stick rigidly to your own admissions policy. So, I just mentioned that because it's a known goal. As Catherine says, schools the courts have said this, are not substitutes for family law courts in relation to admissions disputes. So we have a lot of support from the recent cases that Catherine has outlined. Important that the courts have said this as well. Special needs students are subject to your school's code of behaviour. That's an important thing. But you need to demonstrate that you have gone over, above and beyond to take account of their needs. And this is again referencing one or two of the cases that we mentioned, where you have documented, the efforts that you have made in order to meet their needs. It's all right coming to us and saying, I've done everything. we're going to say to you as day follows night, great, wonderful. Can you send us evidence of that in cases of dispute? You know, and you should consider, as David said, a behaviour of concern policy, because it's a very good thing to have, and it's very good protection to the school to have. And David has given some guidance of what a policy might look like. So, on Focal Dernock, what I would just say to you is thank you for joining us today. We really welcome the huge numbers that join our webinars, and it's a great encouragement to us. I hope you found it helpful. You will get an email from our team in here asking you to, as you did previously, asking you to complete a questionnaire. Please do that, because as I've said before, it keeps us on our toes. It's really helpful for us to know what works, what doesn't work, or whatever it is. We always get a response that, you know, why didn't you turn on the chat line? And it's something that we really can't manage with the large numbers of people on them. But we hope that the opportunity to give us feedback will allow you to at least engage with us in terms of the webinar. Other than that, from us all, thanks a lot for joining us.
Thank you.
Bye. Thank you. Bye.